All right, well, we're going to go ahead and get started. Welcome, everyone. I am so delighted to see so many people here today to discuss what is going to be a very interesting discussion on a really important topic here. I am really pleased that so many people know about CAPI. If you are not familiar with our work, you should definitely check out our website. You can follow us on Twitter. I have just learned how to do it, so we will be tweeting now. And you should definitely attend more CLE events in the future. Our next CAPI event is going to be next Wednesday, March 6th, which will be at noon. This is going to be focused on preserving the integrity of the financial markets. We're going to have representatives from the SEC, from the U.S. Attorney's Office, and from the Attorney General's Office to talk about the priorities of their agencies and sort of what trends they see and sort of the corruption of the markets there. So it should be an interesting discussion. And on March 27th, also at noon, we will have our version of March Madness here. We'll have a panel discussion talking about the recent scandals that have been plaguing the NCAA, the federal charges that were brought. So that should be a fun conversation as well. So finally, CAPI is very pleased to always offer these CLE events free of charge, which is a priority of ours. However, we also got to keep the lights on. So if you are interested in donating to CAPI, we do have information on the table outside about how you could do that. So please file that away in the back of your head. Okay, so let's get started. I'm going to make some quick introductions here. We have a lot of panelists, and they all have had very illustrious careers. So I am definitely going to truncate all of their bios. They have undoubtedly done more incredible things that I'm going to tell you about. So first of all, I'm going to introduce my co-moderator over here, Jim Gatta. Jim is a partner in Goodwin's Government Investigation and Enforcement and White-Collar Defense Practices. Before he was at Goodwin, Jim was the chief of the criminal division at the U.S. Attorney's Office in the Eastern District of New York. Jim was also the chief of ED&Y's Public Integrity Section, which makes him a perfect person to moderate this panel. And Jim was, importantly, 2 days senior to me in the office, which he has lorded over me for all these years. We have, to my right, Dan Alonzo. Dan is the managing director in Exeter's New York office, where he focuses on monitorships, investigations, and financial crime compliance, including anti-bribery and corruption. He also serves as Exeter's general counsel. Dan was also the chief of the criminal division in the Eastern District of New York, and before that was a state prosecutor. Dan has written extensively about this commission and was really instrumental in helping us put this panel together. To Dan's right is Christine Hammond. Christine is the executive director and founder of the Prosecutors Center for Excellence. Her center provides consulting and research services for prosecutors and supports statewide prosecutor-led best practices committees, which are devoted to proactively improving the criminal justice system and assessing emerging issues. Christine has served in almost every prosecutorial-related position possible. She was the executive assistant district attorney to DA Robert Morgenthau in the Manhattan District Attorney's Office. She was the executive assistant district attorney for the Special Narcotics Prosecutor. She was the New York State Inspector General. She is the chair of the New York State Best Practices Committee. And in all her spare time, she is an adjunct professor at Georgetown. And to Chris's right, we have Dan Richman. Dan is the Paul Kellner Professor of Law here at Columbia Law School. Dan is a former federal prosecutor who served as the chief appellate attorney in the U.S. Attorney's Office for the Southern District of New York and has served as a consultant to the Department of Justice and the Department of Treasury on federal criminal matters. Before he was a professor here, he was a professor at Fordham, and he was appointed by former Mayor Michael Bloomberg as the chairman of the Local Conditional Release Commission. Dan has written over 30 law review articles and offered testimony as an expert in a number of congressional hearings. All right, to my left, I'm pleased to introduce Tom Hoffman. Tom is a lawyer here in New York who really brings a great expertise to this topic. Tom has worked on a number of wrongful conviction cases, including a well-known exoneration of Kareem Bellamy, who was convicted of a 1995 murder and spent about 14 years in jail before having his conviction overturned. Tom has been a huge proponent of this type of commission, this level of oversight, and has really worked for the past over 6 years trying to get legislation like this passed. Next to Tom, we have Todd, which will not confuse anyone here. Todd is the New York State Senator for the 9th District in Long Island. He is a former federal prosecutor who specialized in fighting public corruption. As a senator, Todd has been a crusader for clean government, tax relief, and quality education, and a vigorous advocate for the environment, individuals with disabilities, veterans, first responders, and Israel. Tom has really shown himself to be a leader on ethics reform. He sponsored legislation to strip pensions from corrupt officials, ban outside income from politicians, strengthen anti-bribery laws, bolster penalties for public corruption, and protects taxpayer dollars by increasing oversight of local government contracting. Hope I got all that in there. And next to Tom, we have Miriam Krinsky. Miriam is the Executive Director of Fair and Just Prosecution. This is a project that supports and connects recently elected leaders of prosecutors' offices that are committed to new ways of thinking and innovation. Miriam has spent the past decades working in public service, justice system reform, and academia. She was a federal prosecutor for over 15 years, both in Los Angeles and on a strike force in the Mid-Atlantic region. In 2012, Miriam served as the executive director of the LA County Citizens Commission on Jail Violence, which is a high-level commission appointed to investigate allegations of excessive force by the Los Angeles sheriff's deputies in LA. She's taught at UCLA, at Loyola, Southwestern law schools, and her focus has been on youth at risk and juvenile justice issues. She also serves on various bodies, including as the president of the Los Angeles County Bar Association. All right, enough of hearing me talk. Let's dive into this. Maybe I'll let Jim start us off here.
Okay. All right, so before we start with talking about the commission and the new law, why don't we try to set the playing field a little bit with regards to what are the common claims of misconduct that are leveled against prosecutors. And so I was going to have Christine take this one if you wanted to.
I can.
So, given obviously the positions that you've had and, being responsible for overseeing the training and development of so many assistant district attorneys, what are the most common claims leveled against prosecutors?
Okay, we actually undertook a project that was more laborious than we thought it would be when we started, but we went and looked at the 600 cases in the past 5 years in which prosecutorial misconduct was mentioned in New York and did an assessment. It turned out to be quite laborious. And what we discovered, I don't have the numbers in front of me. Had I known you would have asked me that question, I would have given you the numbers. But by far, the complaints against prosecutors that were founded, the large majority of the claims that were made were not founded, but the ones that were tended to be heat of battle violations, summations where you can't help yourself and you call the defendant's mother a snake or something like that, which you're not allowed to do in New York. So heat of battle complaints were by far the vast majority of them. I think, and Tim, I don't know if you can remind me, was it 11 out of the 600 that were actually founded Brady violations? Yeah, it was less than 20. And we did that analysis because there was so much information bandied about without much real research, and so that was number one. But number two, we wanted to see what in fact the violations were so that we could do a better job of training prosecutors on the things that they were doing wrong.
So there's a couple things in there that you mentioned. You talked about, I think it's on. Maybe we should define what we mean by misconduct, right? Because we're going to be
that's one of our favorite topics too.
Around a lot today.
Right.
Yes. So, and there might be different views amongst the panelists, amongst people in the room, as to what exactly that means. But from your perspective and the perspective of the group that looked at these allegations of wrongful prosecutors, how was misconduct defined?
For the people who are prosecutors in the room, they'll understand this. What we saw was that the quote-unquote misconduct was actually error. There were some instances where, very, very rare, where it was intentional and it was misconduct, but the lion's share of the founded allegations were error. And as you probably know, the ABA, maybe 10 years ago, issued a resolution saying that courts should stop saying prosecutorial misconduct when in fact it was error, mistakes that lawyers make. We know that when a defense attorney makes a mistake, it's ineffective assistance of counsel. When a judge makes a mistake, It's not called misconduct, and so it felt like it was inappropriate to use the word misconduct for prosecutors. I do know there are some states where the appellate units of the prosecutor's office insist on making that change and ask the courts to change the language in their decisions. How successful they are, I don't know, but some states have tried to change that.
Has the intentional wrongdoing, like the knowing that there is a standard and intentionally going past it or not following it, has that been the way that most people thinking and talking about this issue have defined misconduct, or does it run the spectrum?
I think the public thinks that there's tremendous amount of intentional misconduct by prosecutors.
And what I'm hearing from the study that you did a couple years ago was that, in fact, it's more error than intentional misconduct.
By far. First of all, the lion's share of the 600 cases were unfounded. And then of the founded, Tim, was it like 53 founded out of the 600, and then of the 53, 11 were Brady violations, and the remainder were, as I say, heat of battle. You say something in an opening or a summation you shouldn't say.
Tom?
So I have to disagree a little bit.
Excellent. Get a mic. Do you have a mic there, Tom?
I've looked at a lot of, I'm sorry.
There you go.
You know, I've looked probably at over 100 claims of a wrongful conviction. These are not mistakes, I'm sorry to say. They're intentional. And for instance, I'll give you a current case that I have. Where someone was convicted in 1995. And 3 perpetrators committed this robbery and attempted murder. 2 were guilty. Third person always maintained his innocence. There was a statement that was made by one of the co-defendants before he was even arrested, where he confessed to the crime, admitted that the second person was also there, but the third person was not my client, Robert Majors, but someone called Rashid. Right? I think we all know what Brady is. Anything that is favorable must be turned over. That's basic element notion of due process. What we also know is the prosecutor decides what is favorable or is not favorable. And we don't know whether or not there is information that has been withheld until after all appeals are completed and there is a FOIL request. So we got this affidavit that a third person had been identified 21 years later, May of last year. And we also got a statement from a witness who did not testify that the person who supposedly was my client had waist braids cornrows, not the short hair, my client. Now, we're litigating this, and basically the prosecutor is saying, well, I don't know, this wasn't really material. We didn't believe that statement. We didn't believe this affidavit. So we didn't have to turn this over. Hopefully we'll win that litigation. So it's possible that if a complaint is made, and I don't know where you would submit such a complaint. Do I submit it to the same office which withheld this information for 21 years? Where do I go? To the disciplinary committee that has never disciplined a prosecutor for a Brady violation. I will repeat, never. Now, if I may just finish. we know of prosecutorial misconduct. We have done a survey in one county where 136 cases were reversed or remanded based on prosecutorial misconduct. Not mistakes. These are not mistakes.
Which county?
Excuse me?
Which county?
Queens. Queens.
What time period?
Which has never had an exoneration in over 10 years. Brooklyn has had 23 or 24 in the last 2 years. Queens has never had an exoneration in over 10 years. So there's no place to go. You know, necessity is the mother of invention. We have to do something. We have to hold prosecutors accountable. And I was going to say on those cases that were reversed, and I'm sorry I'm taking a little time, on those cases, and we all agree that a wrongful conviction is a catastrophe. Nobody wants to see that. We all want to correct it. And I want to say this. There's a lot of wrongful convictions. The estimate is 20,000. Maybe it's 100,000. We know there's a lot. So on those cases that we found misconduct, that we surveyed, we were able, because we had a civil case, to ask all of those prosecutors, I'll limit my time later, all of those prosecutors, please give us the personnel file and tell us what happened when the case came back and the case was reversed for misconduct. What did you do? Did you reprimand? Did you put a letter in the file? We're not even talking about termination. Did you give a warning? Not a single one. We've looked at 25, and then they stopped discovery, which hopefully will reopen soon. So we need to do something. Obviously, we need to do something. Most cases of wrongful convictions are due to misconduct. There's no question about that. So I think the commission is important. I'm sure the prosecutors want to tweak it, but they have never come up with any alternative solution. Never. What their solution is the disciplinary committee, which is never disciplined.
Well, Tom, can we follow up on that point? Just,
I'm finished.
I want to lay the groundwork so everyone's sort of on the same page. And Dan, maybe you can just speak to this. Sort of, what is the current process? You know, as Tom was saying, there's, you know, what is somebody to do if, you know, confronted with a situation where they think there is misconduct? What is sort of the current landscape that we have, you know, pre-commission?
So there's a lot to unpack in what Tom said eloquently and passionately, and I don't at all in any way deny your passion. It's obviously these are serious cases, and I think that you know, a lot of the New York City DAs and the upstate DAs have established conviction integrity programs, and even if they haven't established them, they obviously take these cases very seriously. So we start with that proposition. So your specific question, I'm actually a member of the grievance committee in the first department. The views that I'm expressing are my own, obviously. So there are two main provisions of the rules of professional conduct that apply to prosecutors specifically, right? Everything applies to all lawyers, and there are some specific ones for government lawyers. But for prosecutors, there's Rule 3.8, and I think it's A and B in New York. One is don't prosecute without probable cause. The other is if you know of a piece of evidence that has a favorable or mitigating effect, you are required to turn it over, and there is no materiality piece of Rule 3.8b. So pretty much by definition, if you violate 3.8b, it has to be knowing. But that's different than Brady, right? So you have a real disconnect there. Brady, it's strict liability, essentially. If a clerk in the police department knew about a piece of information and didn't turn it over, then that's a Brady violation, and some courts might call that prosecutorial misconduct, but it's certainly a Brady violation. To be an ethical violation, it has to be knowing on the part of the prosecutor. Don't prosecute without probable cause. I mean, you can say that that has a knowledge requirement too, but it's kind of strict liability as well. So that's the the two main things that apply, plus everything else, don't suborn perjury, correct the record, all those things that apply to all lawyers, including criminal defense lawyers, who, in my experience as a member of the grievance committee, there aren't very many complaints against criminal defense lawyers, and there aren't very many complaints against prosecutors. And maybe that's part of the problem. People aren't complaining enough, but certainly other than maybe corporate lawyers, we see the fewest complaints against prosecutors. In 4 years as Chief Assistant DA in Manhattan, I saw a handful of disciplinary complaints against prosecutors, and they tended to be for things like, a complainant saying he didn't return my phone call. So it's relatively rare. Tom doesn't know, and I don't know, that nobody's been disciplined for a 3.8b violation, because there is such a thing as private discipline as well. So the judiciary law provides for something called an admonition, which is private discipline does not make it into the public record. I take no position on whether we should change that. All I'm saying is that that's discipline. That's something you have to report. You always have to answer yes if you want to be a judge or you want to get malpractice insurance. It's a censure that is public discipline, and that does make it into the public eye. And from time to time, prosecutors are censured or suspended. The example that Chris just whispered in my ear is Mary Rain from upstate, I think it was St. Lawrence County, was it? And she committed a whole host of violations. In fact, it's, to me, the case of Mary Rain, who got suspended for 2 years, is evidence that the disciplinary system is not broken, that it works pretty well. I have a lot more to say on this, but I want to answer your specific question and not hog everyone's time.
And it was the DA's Association who brought the complaint.
Right. The DA's Association complained against Mary Rain.
So I want to turn to Todd here for a minute. So as our representative of the legislative branch here, can you tell us a little bit about how this commission came to be and sort of what was sort of the behind the scenes of, within the legislature of this, and, just put it a little bit into perspective for us from that side.
Yeah, sure. So how the bill passed, the commission passed, is actually fascinating, and I think it mostly speaks to how prosecutors are in the lowest esteem possible of people that you could have low esteem for in Albany. It's actually scary because it passed with a Democratic Assembly and a Republican Senate, and it passed with overwhelming support on both sides. I was the only Democrat to vote against it, and almost every Republican voted for it too. So how can that be? And I think that there are two things going on. On the Republican side, I have a very cynical view of why it passed. I don't think there were a lot of upstate Republicans worried about wrongful prosecutions. I think there was a feeling among that conference that prosecutors, by the way, not even the ones subject to this law, federal prosecutors, had made political cases against powerful Republican senators. Skelos, Libis, Spano, we can go on. And I heard it directly from their face. A prosecutor will indict whoever he wants, whenever he wants. It's ridiculous. We need to have some restrictions. Now, the very things that Mr. Hoffman was talking about that Democrats proposed to address issues like this, such as discovery reform, bail reform, speedy trial reform, were rejected consistently without any conversation at any point from those same people, right? So I would feel like it was a more genuine concern on their part had they said, let's turn over things in a more transparent manner and faster, but they didn't. They said, no way, there's no way we're going to give, in their words, give criminals access to information faster. But holding prosecutors accountable was something they really wanted to do, and I was very skeptical of that. And look, I got up on the floor and I said, all right, let me get this straight. The Speaker of the Assembly convicted. This majority leader of the Senate convicted. The one before him convicted. The one before him convicted. And our answer is to put a handcuff on prosecutors? Like, I must be in Albany. And I just put the microphone down, right? So on that side of the fence, I think that's what was happening. On the other side of the fence is, I think, a more scary notion, because that's us, we're in charge now. And the view of prosecutors being win at all costs, have no idea how your actions, or don't care about how your actions, or in the worst case scenario, maliciously are happy that your actions hurt other people with outside the bounds of justice, is the prevailing view, right? I get that, Todd, not all prosecutors are like you were. I don't know how they know how I was, but I appreciate the sentiment. But that is certainly that the news, especially the news coming out of former DA Hines' office, is just one bad piece of news after another about innocent people getting out of jail, having no recourse, just awful stories. And the good work that prosecutors do, that I hope everyone in this room would at least think that certainly the vast majority of prosecutors I work with, both in the Queens DA's office and in the U.S. Attorney's office, were really great people. There were bad apples, of course, but that's not the view in Albany. The view in Albany is that it is an unjust system, and that prosecutors are in charge of an unjust system. Now, so there are two questions to unpack within that. First is, okay, so is this then the right mechanism to address this? But when this passed, remember, there were no other mechanisms because criminal justice reform was a conversation that was shut down. And so the order that we had to go in was, especially with the politics of people saying, look, I can't vote against this. My community really wants criminal justice reform, and this is in front of me. I can't vote against this panel to hold people accountable. It's unjustifiable. So it passed overwhelmingly. The issue on the table now is, where does that panel fit within our discussion of other criminal justice reform, turning over witness information in discovery in a different manner, speeding up the time in which prosecutors have to bring cases to trial, et cetera, so, or even holding people in on pretrial release. So it was a very weird confluence of circumstances, and look, it was my argument to people at the time that there are problems, but you don't cure the cold by killing the patient. And basically, you would have political appointees who I think we could maybe all agree in this room, when you have a political system set up, you're not necessarily getting the best people representing the best aspects of the community. You're getting political appointees who are doing the work of the people who appoint them, sitting on a commission deciding cases, and deciding cases before they are even resolved. Right? So you could have a case where, the average case that I make isn't really about innocence or guilt, but there are a lot of times where prosecutors won't bring cases that families of victims would like them to bring, especially in simple vehicular cases, right? Someone is looking at the radio and kills someone on their bicycle, God forbid. This happens. The family wants that person nailed to a wall. Sometimes a prosecutor will make a different decision. If 2 weeks after the decision to not indict or to not bring a case or what have you is made, someone could bring a charge in front of a disciplinary committee against that prosecutor's office, I guarantee you that will change the behavior of the prosecutor's office. And the idea is that you're supposed to do justice no matter what the results, and I think this would seriously alter the equation. So my answer was always, let's get to the heart of the matter, whether it's in discovery reform, bail reform, speedy trial reform, and that's actually happening as we speak. Some of us have different opinions on where we're going to end up on that, but I certainly thought it was a very interesting situation that produced the law last year, and one that I probably may not have happened had it happened at that exact time, but that's where it is now.
Can we talk a little bit about the commission itself and what the law has provided for? Todd, you mentioned a couple of the aspects of it. There are political appointees, a commission of 11 members. If one of you wouldn't mind sort of going through, Dan, you're ready. Going through.
Born ready for this.
What is this commission?
Well, they're laughing because I wrote an article analyzing the statute. It's out there in your materials, so that it's relatively fresh in my mind. Before I tell you about this commission, let me tell you generally about commissions. I completely agree with Todd that when you get a group of political appointees, particularly when they're appointed by the top leaders in Albany, it doesn't always work out. Sometimes it does, but it doesn't always work out that you've got kind of impartial people who really have the best interests of their mission in mind. And that's, there are examples of that in Albany. Whether that would happen here, I don't know. I will say that two other commissions, the kind that are kind of blue ribbon commissions that were both put together by Chief Judge Lippman. One's called the New York State Commission on Statewide Attorney Discipline, and the other one's called the New York State Justice Task Force, each of which contain people from across the spectrum of this issue of criminal justice: judges, defense lawyers, prosecutors, civil litigators, lay people, police. Both of those examine this exact topic, right? The Commission on Statewide Attorney Discipline examined it as a prosecutor misconduct commission and first found no support in those exact words for the perception of rampant prosecutorial misconduct, which is ignored by disciplinary committees. That's my experience as a member of the grievance committee as well. And it found that if there's a perception problem out there, then grievance committees should do better. And that's fine. I'm okay with that. The Justice Task Force looked at something more fair, which is misconduct in the criminal justice system. Let's not forget that it takes two to tango. One player in the criminal justice system is the prosecutor, who has a ministerial role representing the state. The other is the defense lawyer, who has to zealously represent her client. Both of them are there. Both are perfectly capable of ethical transgressions. Justice Task Force looked at whether we should have a special body for that, again rejected it, made a series of recommendations to strengthen the grievance process. The political actors, the Senate Republicans and the Assembly Democrats, ignored that. I don't even know if they read them. And they just went with the absolute wish list of advocates in this area. And so the wish list of advocates in this area is now enshrined in law, which Professor Richmond, I hope, will tell us is an unconstitutional law. But the governor did sign this bill, by the way, acknowledging that it was unconstitutional and saying that it would be fixed later in the year. So to get your specific question, the commission's made up of 11 members. 4 of them are to be appointed by the governor, 1 by each of the 4 legislative leaders, majority and minority, and 3 by the chief judge of New York. And of the 11, 5 are to be defense lawyers, 5 are to be current, former, or retired prosecutors, and 1 is to be, I think it's a law professor with significant criminal justice experience, like Dan Richmond, that kind of thing. So it's meant to be balanced, although we can all in this room think of a million examples of former prosecutors who are much more closely associated with being defense advocates. I mean, the distinguished professor who wrote the book called Prosecutorial Misconduct, Bennett Gershman of Pace, is a former prosecutor who would be eligible to fill a former prosecutor slot on the commission. So there is some, if they're aiming to balance it, there's an issue there. The other structural issue, which I think is, I think it's unfortunate. I've heard people say it's offensive. Like the Commission on Judicial Conduct, the Commission on Prosecutorial Conduct calls for an administrator, a staff member full-time to basically run the commission. That's great. That's normal. Have an executive director type. But that person may not be a former prosecutor, not allowed. So anyone who's a former prosecutor in this room, including me, right, ethics official, I was a commissioner on the Public Integrity Commission, former prosecutor, can't apply. Presumed, I assume, to be biased, which is unfortunate. So that's the structure of the commission itself, and then there are procedures, obviously.
How do complaints, and what kinds of complaints, Todd mentioned an example of one, what kinds of complaints could be heard by the commission? How are they advanced, etc.?
So let me just grab the bill here. In the legislative history, it very clearly says that what they are creating is a, quote, tribunal to oversee prosecutorial discretion. So very clearly, this is all those cases where you see outrage by the victim because the drunk driving case wasn't brought, or the rape case wasn't brought, or the corporate fraud case wasn't brought. The intent of the New York State Legislature is to oversee the exercise of discretion in those cases, or vice versa. If you went too harsh on a drug dealer, or whatever it is, or all the misdemeanor cases that prosecutors are being killed these days for filing, you could be theoretically brought up because it's meant specifically to investigate prosecutorial discretion, going completely against decades of jurisprudence by the Supreme Court and the New York Court of Appeals, saying that discretion by prosecutors is particularly ill-suited to judicial review. So the exact things that the Commission is empowered to look at are the conduct, qualifications, fitness to perform, or performance of official duties of any prosecutor, and they can be removed for cause for including, but not limited to, misconduct in office, as evidenced by departure from appropriate statute, case law, and or the New York Rules of Professional Conduct, persistent failure to perform his or her duties, which would of course require a long-term investigation into the persistent performance of duties by a prosecutor, and conduct prejudicial to the administration of justice. There's also a mental health provision, but that's not today's issue. So it is very, very broad. Depending on who the non-prosecutor administrator is, you can imagine lots of things being looked into. As for complaints, they can be filed by anyone in the world. They don't have to be sworn unless the commission orders, and they can be also be done sua sponte.
And when a complaint is levied, presumably the prosecutor's office has an opportunity to respond, and then is there some sort of formal hearing process?
Yes.
How does it work?
Now, first of all, it's not the prosecutor's office, it's the prosecutor, right? So the prosecutor here is defined as district attorneys and assistant district attorneys, not assistant attorneys general, not the people who prosecute juveniles, not special DAs. It's specifically aimed at the 62 district attorneys and all of their assistants. So they are the ones that will have to do it. I don't know if they will get defense by their counties, by the way. So it may well be that they have to pay for counsel, or that counties are going to incur huge expenses in indemnifying them. And yes, they're given process. There's a hearing. Unlike regular lawyers who get found by the grievance committee hearing officers to have committed misconduct, prosecutors, once that happens, once the recommendation is made to remove them, the entire record becomes public to the world. For regular lawyers in the state, that never happens. The most that becomes public is an appellate division opinion saying what happened. So this is very, very different. One last thing. Discovery reform. The prosecutors get less discovery under this statute than the current proposal for criminal defendants getting discovery in New York. So I think that it rings a little hollow that we want to have open discovery when we're giving prosecutors good discovery but limited.
Miriam, maybe I could just swing to you for a minute. Your experience was, I don't know if I'm on, your experience was largely in California, in which they took a very, slightly different approach in dealing with some of these issues. I was hoping you could talk a little bit about your experience there and sort of what the tack was there.
Sure, and since you've given me the mic, let me actually offer a few perspectives on some of the dialogue thus far, if that's okay. I think one thing all of us, or most of us, share in common is that we spent time as prosecutors. And certainly the decade I spent as a federal prosecutor was a wonderful opportunity that I'm incredibly proud of, to have every day stood up and be able to represent the interests of my community. But I saw over the course of that decade things that concern me. And when I think about what is misconduct, I guess I'd like to think that we're better than trying to narrow the definition, and that for those of us who spent time as proud prosecutors, what we should want to do is expand the definition and be willing to own the fact that prosecutors, just as I saw during my 5 years when I worked on law enforcement reform and spent time inside a law enforcement department, prosecutors are different. The community entrusts us and empowers us to act on their behalf. So I would often say to people in the law enforcement department I worked with, when the community gives you the right to wear the badge and carry a gun, you're not just going out and doing a job. You're going out with the authority of the community. And when you do wrong, you have a responsibility to that community. So when I think about misconduct, I know we often quibble about what is an innocent mistake and how do we narrow it so that it doesn't include innocent mistakes. And obviously, I'm no expert on this commission or this bill. I know there were problems with some of the details. But in my mind, if there are years of innocent mistakes, isn't that rising to the level of something that should deeply trouble us? What are we not catching? What are we not doing? Who are we not training? Who are we not acculturating to a culture in the office that needs to be better than multiple quote-unquote innocent mistakes? And at what point does a litany of innocent mistakes become more than innocent mistakes? At what point should we not simply say we didn't know, but look at what should we reasonably have known? Who should we have held accountable that we weren't holding accountable? So I guess when I think about the concept of this commission, just as when I think about the concept of a community commission and a community voice in overseeing law enforcement, when we think about the role of those that we entrust with the future of people's lives, which is what prosecutors are entrusted with, I feel like the community should have a voice in that. And I'm not suggesting that they get into the intricacies of, multiple decisions, but I do think there's a role for community co-ownership of what is a safe and healthy place. And the other part of it that I think we have to think about is whether we want to believe there's a crisis of confidence, there is a mounting lack of confidence in the justice system. And we can't keep our communities safe if we don't have their confidence. We can't police them. We can't run a justice system if they've lost confidence in prosecutors and the justice system. And so I think if we start to lose the integrity and the perception of unfairness starts to mount, that's a problem. In and of itself, that's a problem. So let me come back to the California law. I spent 3 years, I was asked by our Chief Justice to sit on it, and to this day I tell her it's the one time I wish I could have looked her in the face and said no thank you. But I spent 3 very difficult years during a challenging time on California's State Bar Board of Trustees. 2 of those 3 years I chaired our Rules and Discipline Committee. And I was really surprised by the lists I started to get of judicial findings of errors and misconduct by prosecutors that were simply not being attended to by our discipline system. And California is not alone in that regard. We know when we look around the country, it is almost unheard of for prosecutors to publicly, and I think publicly matters, standing up and publicly saying somebody's done wrong. I mean, there are reasons for private censure, but sometimes you need to publicly call it out, just as we do with law enforcement. So the number of times where there has been a public disciplinary action against a prosecutor is pretty rare. So we worked on, as part of a massive effort to align California rules with the ABA rules, an amendment to our disciplinary rule that's now 3.8 under the ABA rule 3.8, akin to New York's rule 3.8. Much of it is quite similar to the New York rule, and recognize that also means that it's a disciplinary violation to failure to disclose information, whether or not it meets the Brady standard. It doesn't have to be material. It's still a disciplinary violation. Not that that's commonly found to be a disciplinary violation, but at least the rule says it's a disciplinary violation. The California rule goes further. It also says that it's a disciplinary violation if the prosecutor reasonably should know that the evidence tends to negate guilt. So we decided, over the strong objection of former colleagues of mine from the U.S. Attorney's Office, over friends of mine in the state DA community, to adopt a reasonably should know rule. And our thinking there was that prosecutors should be held to that bar. If you reasonably should know, willful blindness should not be an excuse. So the other thing that happened commensurate with that rule was, in lifting up the issue, there was a state law that was enacted that really has put the fear of God, and I didn't work on this, it just happened, that makes it a felony for a prosecutor to intentionally withhold evidence. And if somebody's life has stood in the balance, as we know for decades, people have spent time in custody based on conduct of prosecutors, well, maybe the fear of God does need to be put into some of us who hold people's lives in the balance. We have now had, I believe, 2 state disciplinary cases under the new rule, and it is really lifting up the issue far and wide. And I think it may start to pick up in other parts of the country. So I can talk later about the law enforcement efforts, but just wanted to throw out that California experience.
Can I say something?
Yeah, please.
That you limited your time?
Thank you. What are you, a career defense attorney? No, this commission is not against prosecutors. There are great prosecutors, and we have just heard from one. this commission is supported by great prosecutors. We all want to have those bad apples reprimanded or disciplined. A lot of the arguments that are being made here was made in the late 1970s when the Judicial Commission was created. Every litigant who disagrees with the judge is going to file a complaint. They're going to be inundated with these frivolous complaints. That didn't happen. Of 1,400 complaints that are filed with the Judiciary Commission in 1 year, Judicial Commission, 1,200 are immediately dismissed. And you know what else happened with this Commission on Judicial Conduct? Misconduct by judges started dropping. Isn't this what we want? So we may have certain little disagreements here, but what we need is that prosecutors need to be held accountable. And while I don't know whether or not there's been any private reprimands, we have asked, and we don't need to know the names of the people, we have asked, how many private reprimands have there been? And there's been no answer. And I think that should be made public. If there has been private reprimands, let us know. Maybe I'm saying something which is inaccurate. The one case which they mentioned, which I said, D.A. Raines, is the one case, you know, they always come up with one instance. You know, what she did was extrajudicial misconduct, and her discipline wasn't implemented till after she already resigned. So that's the one case they can point to. But there are many, many other cases. Not everyone. A lot of prosecutors are ethical and try to do the right thing. And we just heard from one.
Dan, I'm curious to get your perspective on sort of the need for a commission like this, and what sort of is, from your perch here, what do you sort of see as an appropriate level of oversight? Are you in favor of this type of a commission? Do you think this is, you know, going a step too far? How do you see it?
Well, the last thing I want to do is start or even end by saying anything about New York constitutional law. I mean, the challenges with respect to the commission are based on arguments about the sovereignty, in a way, of elected county DAs. And those are interesting arguments. I've had enough interaction with other constitutions to think that if you really wanted to come up with some sort of commission, you'd be able to work something out in a way that would satisfy the New York Constitution, whether you do it through spending arrangements or concessions. You know, I want to put that aside in part because of my ignorance and in part because of my belief that where there actually are good ideas to implement oversight mechanisms, we can figure something out. And if I'm wrong, I'm wrong. But so let's speak to the more general point of, you know, it's interesting that Tom mentioned the Judicial Commission as being a success. And I think that's, to me, illustrative of a larger problem we have, which is figuring out what works, figuring out what's a problem. I look through just cursorily the kinds of cases the Judicial Commission does. There are essentially a whole range of them that are schoolyard bullying by somebody who happens to wear a robe, particularly in the village and county, in the village courts. There are a lot of mishandling of money. So the idea that one can look at that model and say, you know, we know what works is, maybe it's true, maybe it's not, but I remain sort of agnostic as to whether that works. On the question of whether some sort of oversight mechanism is necessary, here again, nothing is perfect. There are, I think, there's going to be a need for a variety of oversight mechanisms. I've heard bar committees being a possibility. As somebody who, when a prosecutor was a grievant in the bar committee, I was radically underwhelmed by their investigative competences. It was against a criminal defense lawyer. It may well have improved since then, but this is really hard to go into fact-finding into the criminal system on the basis of something other than the record. If there's something that happens in court, if a prosecutor goes over the line in front of the judge, or if there's a really neat trail of misconduct, then I could see how a grievance committee could really sink its teeth into it. But I think the challenges for a grievance committee are real. That means it should be a player. We should embrace it. Everything Dan says about efforts to tone up its capabilities, I think, should be embraced. But it's bound, as is anything in this space, to be relatively needing supplementation. Let's just put it that way. Now, where's the supplementation going to come from? I think we should be open. It may well come from some other kind of oversight mechanism that's different from the one proposed. All I think the focus should be on is the need for some sort of entity outside of a county's office to look at what's going on there. I think we're all big city people here, and there's a tendency to focus on particular cases that are coming from downstate, and I'm sure there are interesting conversations that will be had about problems or concerns one has downstate. But if you think of New York State as a whole, there's a whole lot of counties in there, up there, shall we say, that I worry about. I worry about any time you have a small legal community and extensive power on the part of a government actor. Now, where that's going to come from, it may well be through something of Judge Lippman's sort. We need to be open, and I don't think the answers are going to be obviously coming out of this panel. There are only a couple pieces in motion right now with regard to proposals. And when you think of the range of concerns one might have, ranging from systemic problems of the sort that Miriam spoke about, that really go beyond normal ethical analyses but are really needing targeting, that's something we should think about. I don't think a grievance procedure, I don't think a personal accountability is the way to address that, but it's certainly needing addressing. At the other extreme is essentially white-collar crime. When a prosecutor is really aware of evidence that is material, that is so obviously important to the defendant's case, and she conceals it, that's really about the same as a lot of the white-collar crime that prosecutors down the hall are prosecuting. Most of the cases are going to be in between. A lot of them are going to involve more police activity than prosecutors, and obviously everything we speak about here when it comes to Brady violations is probably more likely to be rooted in some sort of police inadequacies than prosecutorial inadequacies. But even within the prosecutorial space, short of that white-collar crime, what's the range of cases we want to address? Some of them are going to be just a prosecutor really overly discounting a piece of evidence, just not thinking about it, and really being wrong in that. We're getting very well acquainted with the various cognitive blinders that people have and tunnel vision that leads prosecutors in particular to think, this is silly. And I know it's silly, and there's no point even thinking about it further. The rules say that ought to be captured, and we need to make sure that the prosecutor is attuned to that. But calling that misconduct, I think you lose something in terms of office discipline when you start throwing around the words misconduct. That's a training failure. And to treat it as an accountability moment that we should pillory somebody for seems to be a bit counterintuitive.
Todd?
Yeah, thank you. So I think this is a great discussion, but I want to speak to your point. Look, details have to matter. And they certainly have to matter for me because I actually have to read the stuff, and some of us do anyway, and have to vote on it. And I think the type of changes that California made are far more helpful, right? We could change the standards of what matters. We could change the law so that prosecutors have to be attuned and have to do certain things by different dates. And if the system's not working, it just seems to me a very weird remedy to go right to punishing people for acting within that system as opposed to changing the system to just making it better right up front. So this is a weird way of how we're ordering things. I certainly think if we are making clear what responsibilities are, we're setting the rules in favor of more transparency, and still there are issues, I would be far more open to considering this. But I also think the details of how it's constructed matter, right? So if you're a prosecutor, you have a judge ruling on your case. Then you have appellate review on top of that, and then collateral review. That is a lot of review, a lot more than a lot of other people have in their jobs, and I agree that it's warranted in light of the seriousness of what we do. But the idea that no one is going to, or few people will avail themselves of this, I just think is not borne out in fact. Who would not avail themselves of this? If anyone could file unsworn for any reason, whether you made a decision or a non-decision, I just think we're inviting abuse of the system and actually making it harder to catch those real cases that we're aiming for, right? So what should trouble us in the middle of the night? What should make us wake up and say, what's wrong with our system? Clearly it's Brady violations, right? You have information, like was mentioned before, that a defense attorney would love to have, and that is not turned over. That is a training failure, it's a failure of character, it's a whole lot of other things. We could change the law to directly address that and directly make that matter, even the penalties for that mattering. But to then just have a wide open system of a grievance panel, I just think is not getting at exactly what we want to get at. And I think there's a way to do that, and I think we're actually in the process of doing that. So I am much more comfortable with a system that actually sets out right from the beginning what matters, what the standards are, and kind of raises everyone to a higher level. I think the idea that anyone could haul you for any reason in front of this political commission may not make people want to be better prosecutors. It can make them want to hate being prosecutors and certainly not like the system that they're in. I'm not sure it's going to raise their conduct up to the level that we expect it to be. I certainly think the California approach is more appropriate, and I certainly think we could tailor an approach in our state that gets at what we want to get at without inundating the system, but more importantly, creating an overly political one. Remember, who is going to bring a case against some senator or some governor down the road or whomever or any person when that person's representative is sitting on a grievance panel that you could be in front of? That is like a chilling effect that we really have to worry about. And I certainly was worried about it in this case. Now, so if we're getting at Brady violations, which I think we should all be aiming for, among other things, but particularly that, we should go particularly at that, not have some wide-ranging commission that could do anything it wants whenever it wants, including fact-finding. We didn't even get into it. It has evidentiary powers, hearings, subpoenaing. So you could be a prosecutor in a case testifying about your case. That's crazy. And I don't think that's what the system is meant to try to do. I think if we want to have different hearings throughout the course of a criminal prosecution about discovery, we should talk about having those for specific reasons, but not having it on anybody at any time to want to bring that, and whoever is appointed to this commission deciding it should go to a fact-finding subcommittee. I just was very troubled by that, and I don't think it's getting at what we want to address.
So Todd mentioned complaints, and Tom said that 1,200 of the cases in the Judicial Conduct Commission are dismissed. So one feature of this statute, which is interesting, is that the commission is required to conduct an investigation if the complaint is facially valid. So if a member of organized crime is being investigated for racketeering and says, the prosecutor lied to me or whatever it is, they have to open an investigation. Maybe it won't be a particularly long one. But more generally, I want to make clear that my thesis here is that this bill is terrible. It will do incredible damage to our system, but I am very much in favor of addressing this perception of prosecutorial misconduct and this crisis of confidence or this lack of confidence in aspects of the criminal justice system. So responding to Dan, I could easily see a constitutional statute that says we're going to create a criminal justice division of the grievance committees in all 4 departments. And we're going to have specialized people. That's one of the complaints, that grievance committees don't have specialization. We're going to have specialized people who do this. We're going to give them more resources, and we're going to say we're open for business. And then that will at least put prosecutors and defense lawyers on the same footing as lawyers, of the other lawyers in the state. And it would be clearly constitutional, right? The constitutional objection here is that this is outside of the appellate division's oversight of lawyers, which is what New York has so far. And then what Miriam said also, yeah, there's a great place for citizen interaction. It doesn't have to be this. It could be, you could imagine a commission required in every state, in every county, that requires citizen interaction with DAs, and DAs are required to interface with them and take their input and talk about things that they can talk about that aren't confidential. I think that's all great. This commission is not great.
So we're in the middle of a bit of a stalemate right now because there's negotiations going on as a result of a lawsuit that DASNY brought. Maybe so that everybody is operating on the same sheet of music. Christine, could you describe maybe the lawsuit? No.
David might be able to.
Well, we have the lead plaintiff is here, the president of the association. Would you like to, David? With his lawyer. Would you like to?
Okay, well, there you go.
You didn't know it was audience participation.
Yeah, so we brought a lawsuit in October, and there was a stipulation filed that prevents any commission members from being appointed except upon 45 days notice. And there's currently there was a revision to the statute. It hasn't been delivered to or signed by Governor Cuomo, but the revised statute doesn't address any of the 7 constitutional infirmities that we identified in our lawsuit. It tweaks certain aspects of them, but it doesn't solve them. So this chapter amendment, which was rushed through in the 3rd day of the legislative session in January, didn't really thoughtfully engage with all of the serious fundamental constitutional defects that we've identified in our lawsuit, that the Attorney General's office identified after the original statute was passed in August, that the governor himself identified in an approval memo when he signed the original statute into law.
Can you just tell us the 2 main ones, just so that, because I think what the substance of the constitutional objection is important to this?
Yes. Okay. So it really goes to just the way our constitutional system works. There's one of the main issues is a separation of powers problem. You have a commission that's a hybrid political commission, the majority of whose members are appointed by non-executive branch individuals. So you have an 11-person commission. It used to be that it was majority legislative appointees. Now it's majority legislative and judicial appointees. And the commission is not accountable to anyone within the executive branch, not accountable to the governor, although the governor has appointment power over 4 of the 11 commissioners. So there's that's the serious separation of powers problem. You also have just the fact that this commission, for the reasons that have previously been identified by this panel, this commission can interfere with and impair prosecutorial decision-making and prosecutorial independence. And that is a separate constitutional problem. You also, a third major defect here is the fact that it requires judges, specifically the chief judge of the Court of Appeals and the presiding justices of the Appellate Division, to perform non-judicial tasks, which the Court of Appeals has very explicitly said is unconstitutional. So although there might be noble purposes behind this commission, and it might be politically expedient to address prosecutorial misconduct with this independent body, it can't do so in a way that's constitutionally infirm. And there are 7, we believe, glaring constitutional infirmities with respect to this commission, and the major ones being separation of powers, the assignment of non-judicial tasks to judges, and the fact that there's an impairment of prosecutorial discretion.
And just full clarification, the District Attorneys Association for the State of New York does believe that there needs to be enhancements to oversight. What we don't agree with is a body that can and in fact will interfere with our prosecutions. We don't have a concern about oversight. What we do have is a concern over interruption. And as the DA who sits in Albany County, who is, a matter of fact, prosecuting and investigating elected officials, the idea that someone could file an unsworn complaint, a member of a PAC, that would interfere in my prosecutions is just absurd. And so we believe in a more enhanced system as it exists right now. We believe, in fact, we would support any kind of legislation that would put more investments into the current body. Mary Rain, the timing of Mary Rain's departure had nothing to do with the fact that she had already stepped down. It had everything to do with that they lacked the resources to conduct a full and thorough investigation in a very expeditious period of time.
May I answer?
Please, Tony.
So I think there was an amendment proposed that the commission would not, investigate when there is a pending criminal action, and that you can then ask that the commission not investigate till the criminal proceeding is over. Everybody agrees with that. As far as, well, and if there was interference,
Say it's part true, right? Because it has a 1 year expiration, so
right.
you can stay it,
Right.
but not if the investigation goes on for 3 years. You could.
this commission will have 6 prosecutors and 6 defense attorneys. They will act in a way as to not interfere and to not create a situation where they're going to punish someone for some discretionary activity. See, what's happening here is we are using, examples which are unlikely to occur. The real problem is summation misconduct, ridiculous conduct which goes over the top and someone gets convicted. The real problem is a Brady violation where someone doesn't find out for 20 years. That's the real problem. These little far-out examples we could fix. But if I may just say, every profession has some accountability, every one of them, except prosecutors, who are absolutely immune. You can't do anything to them personally, and who have never been accountable for.
As a person who has been investigated by that body and have been found accountable, because I'm open about that, what I can tell you is that if you wanted to draw up a specific piece of legislation, right, that addressed the Brady violation issue, because I find that to be reprehensible, and I think every member of my association would find any prosecutor withholding Brady information to be reprehensible. You draft a piece of legislation like that, you would have the support of DASNY. But what we won't do is support a body of political appointments. And by the way, I practice law 100 yards from the state capitol, where there's a number of political appointed bodies, none of whom actually can manage to hold accountable those people that they're designed to hold accountable. And what we don't want to see is another one that interferes in the real work the prosecutors do.
With respect to this question of
There's microphones that are right in front. That way we can all hear.
the thing that I've had difficulty understanding, frankly, assume, for argument's sake, that there are cases that a judge has found the prosecutor committed a violation. Where was the judiciary not have responsibility in this regard to refer the case to disciplinary committee? Is that not at all happening? Or is what's going on here really is we're looking for somebody else to take the ball rather than judiciary take the responsibility that it seems to be afraid to take, frankly?
Well, one of the recommendations of the Lippman Commission is to require that all judicial findings be forwarded, and that seems unobjectionable to me. They'll get a fair shake. So
it would be referred to a disciplinary committee in this scheme.
It would be referred to a disciplinary committee, which, I mean, I have to reply to this. The only profession that isn't regulated is prosecutors. I mean, by that logic, the only profession that isn't regulated is corporate lawyers. I mean, prosecutors are lawyers. We're well I'm no longer a prosecutor, but we were well regulated by the bar, just like every other lawyer. I mean, you're not going to start. Why are you singling out prosecutors? I mean, I understand you've said why, but it's certainly not true that we're not regulated. Also, by the way, the governor can remove district attorneys. Himself. All he has to do is tell them why and give them a fair hearing, and every district attorney can remove assistant district attorneys. And you might say, oh, that doesn't happen. That's not true. It does happen. We removed assistant district attorneys. The Innocence Project wrote an op-ed in 2018 pro Wrongful Conviction Commission, pro Prosecutorial Conduct Commission, championing it, and cited the case of an assistant DA in Suffolk County as being, outrageous. It was outrageous that he was only fired. I mean, I'm not sure what else you're supposed to do. Roast him on a spit? I mean, fired is the biggest piece of authority that this commission has. You can't do more than that. So, I'm just really having trouble with this idea that a disciplinary process, especially a beefed up one, isn't enough.
Can I jump in on judges? I do think that judges could play a role, but we ought to be careful about expecting them to do too much. There are a couple pathologies here. One has been discussed of the defense lawyer who, for reasons either personal or client-driven, really wants to jam up a prosecutor. I think there's another pathology too, which is the defense lawyer just trying to do the best she can for her client, who is smart enough to know that you ought not to be focusing on intentional misconduct if all you need to do to prevail is to focus on something far less than intentional misconduct. So you put that together with the fact that the exact role of prosecutor versus police officer may not be fully fleshed out in terms of the way a Brady violation is presented to a judge. I wouldn't imagine that a judge would be particularly well suited to really call what is really worthy of pursuit when it comes to misconduct with respect to Brady. Certainly, sure, with respect to summations or something that the judge has full knowledge of, that's easy. But the Brady piece is hard.
I'm not sure I agree with you, because presumably they will have been full litigation of the Brady. The judge will know everything that went on, presumably, whether it was on papers, or hopefully he would not make a decision until after a hearing. And he would recognize what happened, and he would know the appropriate case that would have to be referred. Certainly there are cases that would not have to be referred. If the police not giving something to the prosecutor, certainly a judge would be able to say that does not have to be referred. And maybe the answer then is for the default position would be the judge should refer, but if he believes there's been a Brady violation, but he does not want to do that, then he has to write something, explain what he's done.
I disagree. Maybe I haven't practiced much, or they're all in New York courts, but I certainly practice in federal courts. I don't think judges are really into doing things that the law does not require them to do.
That's a different question. That's a different question. That's true, Judge. It's the same reason why if you will never, ever find a circumstance in which, let's say there's been misconduct on both sides, and you'll never see a defense attorney grieve a prosecutor. You'll see a prosecutor grieve a defense attorney because the can of worms that will open. But the judge presumably is going to be someone who's somewhat neutral. It's not going to be viewed as he's just trying to get back at me, or he's just trying to do something nasty. And in that circumstance, that might be the best solution.
No, that's not what I'm referring to. What I'm saying is to find a Brady violation and to really look into what she needs to understand to find a Brady violation. A judge does not have to do the fine-grained fault laying between prosecutor and police officer. It is enough that she looks at the state or people or government as a whole and makes a decision. That is what her focus will be, I assume, when finding that there's a violation, and that just will often be not sufficient.
Can I jump in? Because I think this exchange is interesting, and I'm actually not entirely sure the two of you disagree. I think one problem here is that there's an empty chair. And the question is, who's going to fill that empty chair, and how does it get filled? And from everything I've heard, there are ample problems with this legislation. So I'm not suggesting that this legislation is the perfect solution, but somehow that empty chair needs to be filled. In the federal system, if a judge finds misconduct, there's a requirement that be reported to OPR. So there is an empty chair that gets filled there. There is another body that steps in, that does an independent investigation. Just as we know in law enforcement, best practice says an employing agency shouldn't investigate its own. That is not best practice in law enforcement. When there's police misconduct, somebody else should step in and do the investigation. So we, in many ways, I think the comment was made, judges often don't find misconduct. Well, if they do, there should be a consequence. There needs to be a referral somewhere. And who fills that, I think, is an unanswered question still in the state. I think often judicial findings of misconduct are trees that fall in the forest. Nobody hears them, nobody sees them, and nothing happens when they occur. But I think, as Dan's comments pointed out, many times there also aren't those judicial findings because, let's face it, much of what happens in a prosecutor's office is a black box. Not complete access occurs to that information. Again, it's unlike police misconduct where today much of what law enforcement does is recorded, is, being watched by eyes and ears in many places, not all of it, but those parts that aren't being watched out on the street are often being watched by DAs or by civil rights divisions or by others that are overseeing police misconduct. Those don't exist when we look at what the landscape is in regard to prosecutorial oversight. We don't have internal affairs divisions in prosecutors' offices. We don't have the federal equivalent of OPR. We don't have civilian oversight commissions that have become more and more common around the nation in regard to police overreach and in regard to concerns about law enforcement conduct. And I think certainly Brady violations are a huge area of concern for us to think about what should be the mechanism that steps in. But I don't think it is just Brady violations. In my part of the country, we had some real concerns about use of jailhouse informants by a prosecutor's office that led to the very first, under the prior administration, opening of a pattern and practice investigation against a DA's office that probably would have continued but for changes in leadership that happened in Department of Justice Civil Rights Division. We had in that instance a letter that was agreed to by many leading prosecutors around the nation that called for the creation of civilian oversight over that DA's office. I think when prosecutors overreach when it comes to overcharging to coerce a guilty plea, which can happen in some instances, we need to be worried. I think when there's prosecutorial overreach in terms of bail practices that often mean that an individual will plead guilty just to get out because they can't pay their way out of custody, we should be concerned. So I think there are varieties of areas where there needs to be a role for some kind of oversight. And again, I'm not suggesting that this bill was the perfectly polished or even wise solution, but somehow I think we need to grapple with the fact that somebody's got to fill that empty seat. And until it happens, every well-intentioned prosecutor, I believe, is going to suffer as a result, because when there's a cloud in any small way, shape, or form over the profession, the cloud permeates over all of us and is something that we all have to be worried about.
So maybe we can try to grapple with that a little bit at the end here. So we've heard about a Justice Task Force, a Lippman Commission, that the recommendations of which were more or less disregarded, which required infusing the current grievance process with more resources, requiring the collection and publication of data with respect to disciplinary processes involving prosecutors and defense lawyers, requiring training standards be met, raised and met, et cetera, standing order in all cases regarding disclosures and requirements of the defense for notice provisions, et cetera. Is that the right answer? If we went back and took a look at the findings of that commission, or is there something else? Who needs to be stepping into this chair, as Miriam said, and maybe we could kind of all go down the line. Tom, I'm curious with regard to your perspective.
I'm glad to see that there is some recognition that something needs to be done. And perhaps the efforts to create the commission has triggered that recognition. The truth of the matter is nothing has been done before now. Nothing of any consequence. I agree that I am sure that we could come up with a resolution very quickly if we have both sides understanding that prosecutorial trial misconduct must be addressed. If 10 years ago or 5 years ago someone would have mentioned let's have a separate department in the disciplinary units, and we would have all considered that. Now it's coming up, and we already have a commission which needs to be fixed, and possibly in certain areas. But other than the commission, I think that's what every profession is reviewed. We have a disagreement whether prosecutors are subject to the disciplinary committee. Statistically, it doesn't appear that, but they have been disciplined. So, I think if we get a recognition that there is a need, we could resolve this.
Todd, I'm actually curious what your answer to this is. So my guess is you don't think the amendment was effective at all. So what do you sort of see as, assuming that we could create, as Tom was saying, get heads together and create something that is effective as a legislator, what do you think would actually be an effective solution to this issue?
So I actually think the thing I originally wanted is going to happen, which is this is not going to be found to be valid law. And in the meantime, we are going to actually do real criminal justice reform. That's going to get to the heart of some of these matters. And then I think the question is, what do we want to do at that point that we think could fill in the gaps and, I guess, ensure there's accountability? The thing I just want to warn everybody about is Albany is not some place where, like, great legal minds sit and go back and forth about how to make the best commission. It doesn't happen that way. Things often happen at 2 in the morning. They happen because it's, like, this commission. So what happened with this actual commission is 2 years ago, the proponent of the bill, a senator from the Deputy Majority Leader, John DeFrancisco, proposed it, and it was taken off the docket at like 11 at night. And I was about to debate him on it, and I was all prepared, and it got pulled, and he was really upset, and he stormed out. I don't know why he got pulled. But it was his last day at session last year. He was retiring after 40 years. And this was like his gift to him. And all of a sudden, within maybe 10 hours' notice, it was on the docket. It hadn't been discussed all year. It was rushed to the floor. It was debated for 10 minutes, and it was passed. Like, that's how Albany works. So, and we're going through that with criminal justice now. I hope we get something good. Now that I'm in the majority, I get to be in the room and help make some of these decisions. I don't win all of them. I don't know what will happen this time around. But I just want to caution everyone, what you want going in is not necessarily what you get coming out. And I think the work that, we're debating discovery. I can't really talk so much about our internal discussions, but the Justice Task Force the State Bar Association wrote a report on discovery reform. I was the only one who read it. All right? And when I was like, it says this, people go, all right, we'll take a look at that. But, people put a lot of work into it, and I'm not sure so many people had it at their bedside when they were going through the legislation. So it's something we got to be careful about. There's certainly nothing wrong with, and can only be helpful to have people who do this for a living, like the Justice Task Force or other groups of lay people, come up with the best ideas. But unless you want to get really political and roll up your sleeves and start lobbying, get your asses up to Albany and start waiting out in the hallway so you could talk to legislators from when they're going to the bathroom to this hearing room and back and forth, don't get in this game, because that's how it works. And I tell prosecutors all the time, so when we had when we had 10 hours notice of that bill last year, and I got on the phone with every DA I knew, and I said, call your senator. It wasn't like every DA had the cell phone of the senator that he or she needed to get to in time. It was they were not ready. And I don't know whether anything could have been done. I tell you who was smart was a former Attorney General Schneiderman, because he got attorney generals written out of the law and then he stopped lobbying against it. But that's the type of thing that happens, and I just think you got to be prepared going in for it for like a totally bizarre and like weird bended mirror universe. Then every now and then something good comes out of that, but you got to know how to play the game.
Christine, I'm curious to hear your thoughts since you guys have really looked into the problem. What do you see as kind of an ideal solution?
I think I would just echo what other people have said, which is the disciplinary process being beefed up. The work that I've been doing with the DA's Association sort of takes on a slightly different tack, which is that we work internally on these ethics issues and are far more introspective about them than we used to be. I'm not saying that's the whole answer, and it doesn't address what Miriam mentioned is about the sort of general cloud over prosecutors. But I do know that we have started conversations amongst ourselves about what we need to do and what our responsibilities are. That's different from a more public process, and I do think that the public process of enhancing the grievance committee is an excellent one. The fact that you can't get a statistic from the disciplinary committee about how many complaints have been brought about prosecutors is pretty astounding, that you can't even get that number. But I do know that we're working very hard amongst ourselves to try and figure out what more do we need to do, what can we do to heighten our concerns about ethics within an office and within individual prosecutors.
Well, I want to make sure we leave enough time for questions too, so maybe I'll open up the floor if you have questions. I just ask that you turn the mic on since we are recording it. So, go ahead.
Yeah, just one area. I wouldn't call it a narrow area, but just some of the comments earlier made me curious about pursuing this. One of the many areas in which our tradition and law is that prosecutorial discretion is not reviewable is with respect to decision not to prosecute. That even the courts have even found that regulatory agencies with civil sort of quasi-prosecutions are not reviewable in that regard. So I was just wondering how much of a problem has it been? I mean, do we often find, for example, corrupt decisions not to prosecute? Is that something that, and if that happens, I would have thought that probably is investigated by other bodies like the FBI, let's say. So is that something that needs to be in this area, a decision? Because the pitfalls that were explained earlier about what how that could be, it could be very problematic to have the decision not to prosecute be reviewed in this context. I found rather disturbing. So how big a problem is that?
It likely will not come up ever. I mean, it does happen. We have that Epstein matter down in Florida. But those are not. This is not one.
So might not that be a good thing to exclude from this area?
Yeah, I mean, I think we could have a discussion about that. That's not what our concern is. Our concern is trial misconduct, which deprives a person of a fair trial and results in his wrongful conviction. That's what we are.
That's my point. I understand that is the problem we're trying to address, and so these peripheral things that might cause unanticipated problems are perhaps something we should try to move out.
Anyone else want to weigh in?
Well, I think it's an interesting question. I actually think there is oversight of decisions not to prosecute. Certainly if it's a corrupt decision not to prosecute, I think there's a mechanism, and probably it would be a federal investigation review, and those have happened. We know that prosecutors and DAs every day make decisions about where to use the resources of their office, how to use them wisely, how to be smart about it, and where to desist. And I think that that's a critical decision that DAs more and more are making. Is it wise to prosecute, marijuana cases? Is it wise to prosecute, turnstile jumping cases? Is that what our justice system should be focusing on, or should there be a focus in other areas? And I think it's incumbent on prosecutors to be transparent about those decisions, and the oversight is at the ballot box. If the community doesn't believe that reflects the values of the community, just as if the community believes the decision to prosecute those class of cases doesn't reflect the values of the community, there is oversight. They have the power of the voting booth.
Totally agree, but the structure of the commission is a tribunal to oversee prosecutorial discretion, so there's no carve-out to, you can imagine somebody, I mean, it's happening right now. The Manhattan DA is, absent extraordinary circumstances, not prosecuting fare beating, right? I believe you, David, wouldn't prosecute the Occupy Wall Street guys, right? And the courts have indicated you. They said that was your discretion, right? The answer is for the voters to vote you out, right? Right, good. Good luck. So you can imagine, I mean, that kind of thing's happening all the time on a systemic basis these days, marijuana being a great example. And it's also happening, I've been an observer of this for a long time. There's a lot of criticism of prosecutors for not going forward, particularly in sex crimes and corporate fraud. Those are two areas where in individual, and police misconduct of some sort, excessive force, police-involved shootings, those areas where, I mean, we can't talk about what happened in the Garner grand jury, but the DAs are here. People were outraged. Oh my God, how could you not go forward? And those actions by prosecutors are entitled under the law to a presumption of regularity, but people get very angry about it, and I guarantee you if this goes through, those kind of things will result in complaints. You guys get to oversee prosecutorial misconduct. This is a pattern of dereliction of duty. You should discipline them for this.
Can I just jump in the sense that, not to disagree at all, but I do just want to remind us all that what you said, and I think we all kind of agree that the place to start is trial misconduct. You have to remind yourself, trials don't happen in the United States. We have almost no cases that go to trial. So do focus on them. They're our flagship. If they aren't good, we've got a real problem. But the idea that we should stop worrying beyond that, and I'll continue the worrying on to the cases not pursued, in the sense that, yes, if there's actual corruption, there might be, if the information comes to light, because it'll be closely held, some sort of criminal repercussions. But that's not what we should worry about. We should worry about the failure to prosecute X because he's a good boy and we've known him all the time and he wouldn't do anything bad because I know his mom. That's not corruption in any formal sense. But if you're thinking of prosecutors as being this really animal in need of some sort of accountability, we need to think about those cases. I don't suggest in any way that this commission or any of the mechanisms we spoke about here address that, but we as citizens ought to be a little troubled. It always amazes me how everyone thinks of prosecutors as being these overzealous animals when, they work for the government. They're as likely to shirk as they are to be overzealous.
Can I jump in on that? Look, I also think when you're a young prosecutor, you work within the system that you're given, right? So in Queens, the deal is you have X amount of days to offer a plea, and if it's not taken, boom, right? I guess there's an exception once a year where you could persuade a boss to do something different, but like if someone decides they're not going to waive their right to a speedy grand jury indictment, it's over. They don't waive 180, you're not negotiating with them. Again, they either take the top plea or you go to trial, right? I'm sure that there are lots of cases in this country that because of very tough bail policies, very tough discovery policies, and people's situations being locked up unnecessarily, and once again, there's a lot more of those than there are trials. And that's why I think specific legislation remedying the actual system makes a lot more sense than something like this, and would get to the heart of a lot of those issues.
Other questions?
Yeah, I just had a question. Can you hear me? I just had a question about where we are with discovery reform. I mean, we've been talking about Brady material here, and I got to tell you, I was a prosecutor for almost 25 years, and my worst nightmare was a Brady violation. The last thing in the world I wanted to do was go after an innocent person. So if we're talking here about the main problem is a Brady violation, then what has the state legislature done in terms of discovery reform?
Yeah, so I think it's going to happen relatively soon. The issue is just protecting witnesses. So right now, the bill that we're all debating would have you release a witness's name and address even in like the most violent cases within 15 days, with a exception to get a protective order and where you could show substantial danger.
Including the address?
Yes. And I am not in favor of that. So we have to work this out. But I totally believe we can work it out, and look, obviously, eventually, you're going to give an address in most cases. The question is it 30 days before trial, or is it 15 days out of an arrest, or where is this going to happen, and how easy is it to get a protective order? I'm in the weeds on this. I mean, out of the 39 people in the Senate majority, I'm the only one who practiced criminal on either side. So we rely on staff on a lot of issues. You have to be an expert in 100 different things you never thought about, like we're trying to figure out how to regulate e-scooters. I can give a shit. It's important. I'm trying to learn as much as I can. I mean, I don't want anyone to get hit by it, but like to get in the weeds of different e-scooter laws, I do the best I can. This stuff I know like cold. So we're in the weeds on this. We're working through it. We will have something good.
I just want to say the new discovery bill is similar to the one in existence in Florida and Texas. And Massachusetts, which discloses the witnesses. Remember, what we have, the big problem, is you go to trial and you don't know what you are up against. That's the big problem. That's the big problem. And you don't know, and you haven't received anything prior to trial. That's the big problem. So this particular problem, in Massachusetts, for instance, where the prosecutor has a right to ask for protective order, they've done twice in 2 years where they've made that request. We're sensible people. If we have a mob gang, we're gonna issue protective orders. And there are other less drastic measures that could be invoked, redacted, and the other one is which you do in federal court. You give it to the attorney, and you say, look, do not disclose this to your client.
All of those are states that allow for hearsay in grand jury process. Where in New York you don't allow for hearsay, which requires you to present witnesses in the grand jury. And that's the fundamental difference. The DA Association is not opposed to early discovery. We are absolutely opposed to disclosing personal information of our witnesses 15 days after arraignment. But we agree fundamentally that we need to arm defense attorneys with more information so that you're having meaningful conversations with them.
In Florida, not only do they provide the name of the witness, you're allowed to take a deposition of that witness. All right? Okay. So this is what we have. We have 1 or 2 far-out incidences which interferes with what needs to be done. Open file so people know what they're up against.
I just said to you that we do endorse open file. We practice open file now. What I'm saying to you is
your county does.
We do, but what we're looking for from our legislature is the opportunity to engage and create certain carve-outs so that we're providing as much information up front, but at the same time protecting our witnesses. That's all we're looking for.
By the way, when any criminal justice advocate comes into our office, the argument that any state that does it, that fought on the side of the South in the Civil War, it's like argument over, game over. They're like, Texas does this, we're done. And then they're like, we'll walk out.
Who else?
More questions?
I saw somebody else that had a hand up at some point. All right. So any final thoughts from our panelists before we wrap this up?
Any predictions?
Right.
So, yeah, I've been observing this for a while. My prediction is that the law is struck down. I think are you Jake? I think Jake's going to win his lawsuit, and the law gets struck down, and then I don't think there's any reasonable prospect of a constitutional amendment passing this. By the way, the Judicial Conduct Commission was passed by constitutional amendment, which is why it's constitutional. Also, it's the only way to discipline judges, right? There is no grievance committee for judges. There's just this, so that's another huge difference. And then I think, if DASNY, is willing to engage in a very constructive discussion with advocates, and I think they are. I think David is actually a very constructive president of DASNY, and I think if they engage in dialogue, and the grievance committees, by the way, my grievance committee should be called to task and asked about this question. We haven't been. I've been shocked we haven't been. I don't speak for them, but we should, and maybe we should consider opening up some of the laws for attorney discipline, not prosecutor discipline, right? Maybe we should make it so that the appeals process is public, so that you know about a misconduct finding once it's been made, and then the appeal can be public. Now, the appeal is over before anyone finds out. So, there are ways to sort of beef up confidence in lawyers. I will say that anyone who wants to reduce the number of wrongful convictions needs to make a connection between being overly punitive against prosecutors, which is what this tries to do, and reducing wrongful convictions. I pulled some statistics that I'd just like to read very quickly because I think they're interesting, right? So, one of the arguments that's made a lot is that New York is number 2 in the registry of exonerations. There's a project at the University of Michigan that lists exonerations, how many there have been since 1989, I think is the time period, right? And so about 2,000 in total. New York has 233. So that, again, you can't argue on anecdote either for wrongful convictions or for witness intimidation by itself, right? You have to look at the numbers. So I looked at how many felony convictions there were in the same period between 1989 and 2017, and there's a lot of different ways to calculate this, but my conservative answer is 2.6 million felony convictions, so 233 exonerations. Now I understand there's undercounting of exonerations, so I understand there's undercounting of exonerations, so I multiplied the number by 100. So I assume that there are not 233, but 23,000 exonerations in New York in that 20 whatever number of years period that is, from 1989 to 2017. And so that leads to 0.88% of felony convictions were exonerations. And that's not good, right? Even one is bad. Even one wrongful conviction is bad, right? But when you've got 99.12% of convictions not being wrongful convictions, well then the system is kind of working the way it's supposed to. It's not good to have any. I totally agree. And I'm incredibly impressed and happy with lawyers like Tom and like the Innocence Project that do find genuinely innocent people that were wrongfully convicted. But these numbers show our system is roughly working the way it's supposed to. It's a reasonable system. It's not perfect, and it's not designed to be perfect. So if you're going to do this kind of drastic change, which is going to chill prosecutors, chill witnesses, if you're going to do that, you better really make the case that this process is going to reduce wrongful convictions even more than that.
So I'm hoping the way this works out, although it's really depending on a timeline that we really can't control. One is the new laws that we may pass, we haven't passed yet, and what their as of date is, meaning when they take effect, is also not set. We also don't know when a law may be stricken, redone, etc. But what I'm hoping happens is we get a little time under a new reform system. And if we are still seeing at that point, and we have complaints from lawyers like Mr. Hoffman that there's still a great need for discipline, then we're going to have to come back and address this again, knowing what strictures a court has given us in terms of what's possible or not. We'll have to come back and do it the right way.
Maybe I have no idea where it's going to come out. I just simply fly into New York now and again. So, but I want to agree with Dan. I think that Jasmine's lucky to have David. We've had the opportunity to work with him, have great respect for him, and I think he is a voice of reason, and that's a very good thing. I do fear longer term in terms of where it will play out, because I saw this in the federal system before the federal sentencing guidelines, where people were frustrated with sentencing disparities, and I think some of us felt someone's got to address this, or the clamps will be put on in a way that nobody benefits from. And I think ultimately that happened in ways that led to all kinds of ripple effects that weren't positive. I think if prosecutors don't step up and try to think about how do we address this, it will come out, the frustration will come out in other ways that won't be to anybody's benefit. And even if this battle is won, I think the war will be lost, Because A, there will still continue to be troubling cases that cast a shadow on all of us, that none of us should be okay about, that go well beyond Brady issues. And second of all, I think that frustration will play out in terms of stripping discretion in other areas where discretion is vitally important. And that's the worry I would have if I were simply sitting in your seat, David, rather.
Most innocent people are still in prison.
I think most innocent people are out on the streets like us.
Yeah, most, wrongfully convicted people, I'm sorry, thank you, are still in prison because we don't have a place to go. They don't know, they can't
Well,
get
but the commission is not the place to go to get
No, I mean,
exonerated.
I just wanted to refute that statistic that you gave.
Well, if there's no further questions, this was a great discussion, and I really appreciate everybody coming out here. Thank you to our panelists. I thought this was professional, and I learned a lot myself. And thank you to Jim for moderating it. Thank you all.